Good morning, everyone, and thank you for joining our session with our guest speaker, Professor Cary Coglianese from the University of Pennsylvania. I'm Aubin Nzaou, and I'm delighted to welcome you all and to say a few words about our program funded by the European Commission through the H 2020 and Marie Curie actions. This month, our series will also feature an additional speaker, and that will be Professor Don Elliott from Yale University on June the 23rd. Please visit our website, www.law.uh.edu/inner-center, where you will find the upcoming events in the series and also a great lineup of our past speakers. Feel free to use the chat box during the presentation, and in due course, we will be displaying the CLE credit slides. I'll now turn it over to Professor Victor Flatt, co-director of the Inner Center and our chair this morning.
Thank you, Aubin. I'm so excited again with the entire program, but particularly with our speaker today. So I have been aware of Professor Coglianese, and I used to see his name in print all the time, and I always want to call you Professor Coglianese because I feel like I want to get the Italian in there.
I'll answer anything.
Well, that's wonderful. But we're so delighted to have Professor Coglianese here today. He's the Edward B. Shills Professor of Law and Professor of Political Science and Director of the Penn Program on Regulation. He specializes in the study of administrative law and regulatory processes. In fact, I can't think of really anyone else in the country at our law schools that is more well known for their work in this area, and in particular with the empirical evaluation of alternative processes and strategies, and the role of public participation, technology, and business government relations and policymaking. Professor Coglianese has authored more than 200 articles, book chapters, essays on administrative law and regulatory policy. And his recent book projects include Achieving Regulatory Excellence, Does Regulation Kill Jobs?, Regulatory Breakdown, The Crisis of Confidence in U.S. Regulation, Import Safety, Regulatory Governance in the Global Economy, and Regulation and Regulatory Processes. He's written recently compared to all of the other work he's been doing on climate change policy and public participation and transparency in federal rulemaking. Again, another newer topic in his repertoire, the use of artificial intelligence by government agencies, voluntary environmental programs, and waivers and exemptions in regulatory law. Professor Coglianese is the founding director of the Penn Program on Regulation. Prior to that, he served as Penn Law's Deputy Dean for Academic Affairs. You have served your time, I salute you. And prior to joining the Penn faculty, he spent a dozen years on the faculty at Harvard University's John F. Kennedy School of Government, where he also founded that school's regulatory policy program. And he has been a visiting law professor at Stanford University and Vanderbilt University. He's been an affiliated scholar with Harvard University. In addition to all of the work he does in his actual jobs, he's a public member of the Administrative Conference of the United States and serves as chair of their Rulemaking Committee. He's also served as the chair and co-chair of several committees of the American Bar Association's section on administrative law, as well as the section's governing council. He teaches courses, no surprise, in administrative law, also environmental law, regulatory law and policy analysis. And he's the chair of Penn Law's Government Service and Public Affairs Initiative. He works with Penn's Kleinman Center for Energy Policy, the Wharton Risk Center, and the Quattrone Center for the Fair Administration of Justice. He also founded Law and Societies Association's International Collaborative Research Network on Regulatory Governance, and was founding editor of the international peer-reviewed journal Regulation and Governance. Professor Coglianese is currently the chair of the National Academy of Sciences Committee studying implications for law and regulation of emerging trends in the maritime sector. He's also served on an Aspen Institute panel on energy governance and provided research and advice on various regulatory issues to the Alberta Energy Regulator, Environment Canada, the U.S. Department of Transportation, U.S. EPA, and the Organization of Economic Cooperation and Development, or OECD. It's such an impressive resume. We're so glad to have you with us. And just by way of introduction, to get as Professor Coglianese starts his talk, he's done so many important things, but one of the most important aspects of Professor Coglianese's work is in empirical analysis of administrative law. And this is how I have known him since I first began to study administrative law myself. And I'm very excited that he's going to be presenting on that today as well. So with that, I will turn the program over to Professor Coglianese.
Well, thank you very much, Victor, for an exceedingly kind and generous introduction and warm welcome. I'm really honored to be here today. I am so supportive of the research efforts that you have underway and the comparative work that you're doing. And I have, in addition to you, Victor, so many others who I have admired for many, many years at the University of Houston Law Center. So it's truly an honor to be here. I'm going to talk today about some empirical work that I published a couple of years ago now, but I think still offers some important lessons and give us an opportunity to think about the role of the courts in overseeing environmental regulation. This is a study that I did with Dan Walters, who's at Penn State Law School right now, but I think in another month or so will be joining the faculty at Texas A&M, so a little closer to where you all are down in Houston. This was prepared for a symposium at Case Western University Law School on the 50th anniversary of the U.S. Environmental Protection Agency. It was founded in December of 1970, so it has really just entered its second half century, and across the years, the courts have played a pivotal role in many instances. We want to try to give some leverage and empirical understanding and perspective to what often are some sweeping claims that are made about litigation over EPA rules. And to start the talk, what I really want to do is go back to a decision by a court in 1971, January of 1971, a decision that was handed down in the DC Circuit written by Judge David Bazelon. And the case involved, actually, interestingly enough, the statute was FIFRA, the Federal Insecticide, Rodenticide, and Fungicide Act. And originally, FIFRA was to be administered by the Department of Agriculture. And when the case was filed, the Department of Agriculture was, in fact, the respondent to the petition, but by the time the decision was handed down in the very first week of January 1971, the U.S. Environmental Protection Agency had been founded, and the powers to and responsibilities under FIFRA had been transferred to EPA. And this lawsuit, then, this decision that Bazelon hands down, has Bill Ruckelshaus as the named respondent, who was then the administrator of the U.S. Environmental Protection Agency, the very first administrator, one of his first months on the job. He gets this decision from Judge Bazelon involving a petition for DDT, and the environmentalists wanted to have DDT banned, and the Department of Agriculture and then EPA in court were defending a decision not to do so. And Judge Bazelon, in this case, the EC Circuit, hands this back to EPA and says, no, you need to do more homework, basically, before you can deny this petition. And what was interesting toward the end of Judge Bazelon's opinion is he remarks about how here in 1971, the courts were what he called on the threshold of a new era, in which he saw greater scrutiny by the courts, which he said had for too many years given just a real pat deference to agencies. Now courts were going to scrutinize the judiciary, and that renewed scrutiny would actually lead to, he said, the diminished importance of judicial review. Why? Because it would prompt agencies to do their homework better. And once they would enhance their own internal processes and analyses, there would be less need for judicial review. So here we are at the very beginning of the EPA's existence, and there is this question on the table about what's the relationship between the courts and EPA, and how will it play out in the future. And he was making this forecast that with time, this kind of increased scrutiny that he perceives himself as providing to the EPA will actually then ultimately lead to diminishing the importance of judicial review, because agencies will up their game. Now, fast forward 25 years, and we have another judge from the DC Circuit, Judge Patricia Wald, who writes an article reflecting on the first 25 years of EPA's existence and the relationship between the courts and EPA over that quarter century. Her paper has the subtitle, "The Uneasy Partnership Between the Judiciary and the agencies." She's looking not just at EPA, but across the board at how the courts have interacted with regulatory agencies. And she does note that the courts did in the 1970s, as Judge Bazelon had done himself in the case involving DDT, began to subject agency action to more stringent review. But she says by the 1980s, things had shifted. And she argued that the doctrine was taking a more pro-agency stance, and she cites the Chevron decision as exemplary of that more deferential or pro-agency stance. Now, nevertheless, despite what she observed as a shift in doctrine from being more scrutinizing of agencies to more deferential, she nevertheless sees a great deal of continuity across those first 25 years. She described this as an uneasy partnership because she says the doctrine still allows for the courts to both defer when they want to defer and to scrutinize the agency action when they want to scrutinize the agency action. And she calls attention to, even in Chevron, how at step one, courts can be very constraining of what agencies do. But at step two, there is an opportunity for deference. And she says that really this tension between scrutiny and deference will continue long into the future, no matter what changes with legal doctrine. What I want to do today is actually take a look now, 25 years after Judge Wald's article, and say, well, what can we say not only about the second 25 years of EPA's existence, but the whole sweep of the first half century? There are key questions here that I think Judge Bazelon and Judge Wald are putting up. is it going to be the case? Did judicial review grow less important as EPA enhanced the integrity of its work over time, as Judge Bazelon would have predicted? Or was Judge Wald basically right in saying that, things are largely unchanged? There's this uneasy tension constantly between the courts and the agencies. And it's these questions, these big questions about the relationship between the courts and the EPA that Dan and I have taken up in this article, Litigating EPA Rules, that was published in the Case Western Reserve Law Review. Now, what I want to do in today's remarks in talking about this project is first, I'll say some more about why I think it's important, this debate about the relationship between the courts and EPA's and its rulemaking, why that's important and why we need to, I think, subject it to greater inquiry. And then I'm going to focus on the question of how often have EPA rules been challenged in court over its first 50 years. And this turns out to be a perennial and important question in thinking about the relationship between the courts and the EPA. Is judicial review, a constant, ever-present reality for any rulemaking that EPA does, or is it, more of an exceptional opportunity? That's an important facet. How often people are engaging in a relationship is one aspect of defining that relationship. And the same thing is true when thinking about institutions. How often are they engaging with each other? From there, I will focus on how EPA has actually fared in court over these rule challenges. Whenever they have found themselves in court, what has happened. On both questions, there has been actually a fair amount of research on both of these last two questions over the years by social scientists, legal scholars, and Dan and I contribute some new data in this project as well, offering for the first time in anything I have been able to see a trend in what EPA rulemaking has been over its first 50 years, just a statistical observation of the trends, as well as indications about the level of litigation over these rules. And we also, though, synthesize the results from a lot of disparate studies, which I think tend to coalesce more or less in much the same way. Once I answer those questions, I'm going to close with offering some thoughts about what I think explain the observed trends. I should say that this study, and maybe this is a way of getting into the importance of understanding more about EPA rulemaking litigation. This study comes at a time when we are expecting the Supreme Court to hand down an important decision in the West Virginia case involving an EPA rulemaking. So we are still obviously living in the shadow of the Supreme Court overlooking and overseeing the work of EPA. And in fact, the West Virginia case is far from the first one that the Supreme Court has reviewed EPA rulemakings. Dan and I have an appendix which we catalog the 43 decisions in the first 50 years of EPA's existence that were handed down by the Supreme Court in cases involving the EPA. Now, one thing you should know with this many decisions is that there's a lot one could say. We have written just an article. And there are others who have written whole books on all of these cases. And of course, anybody in law school, and I'm delighted to see a few of my students who are joining us here today, welcome, Glad to see you. You all know that there's case books on environmental law that are filled with all sorts of decisions by courts and by the Supreme Court in particular in cases involving the EPA. What we do in our paper is a little bit different than what one might find in these books, which focus on really the doctrinal themes and trends and issues. What we do is let's try to take a 60,000 foot view of what is this relationship between the judiciary and the EPA. And we bring data to bear. So we're going to look more at that 60,000 foot level rather than delve into the too many of the niceties of the doctrines that are certainly at the center of these disputes. I don't want to in any way diminish the importance as lawyers of thinking about those doctrinal issues, but I also think it's important to be able to step back at times and get a big picture and understand really what might be going on. And this is, by the way, just to say, not only important by the fact that we can see 43 cases, almost really one per year on average, over this time period in the Supreme Court, but we also see and have evidence of the influence of these decisions that involve EPA rulemaking. For example, we took a look at all U.S. Court of Appeals decisions and looked for how many of those decisions involved the names, had some kind of mention or citation anywhere of an agency names. And we looked at a number of very important regulatory agencies, EPA, Food and Drug Administration, Nuclear Regulatory Commission, Federal Energy Regulatory Commission, OSHA, and so forth. And we one way of looking at the importance of an agency's rulemaking and its review by the courts, one way of looking at the import of that would be to see, well, how much does it make a difference overall in the body of law? And we find, as this chart indicates, that when you look on average across the duration and time period that these agencies have been in existence, and not all of them started at the same time. So we normalize them and look at sort of the average per year during the duration that they've been in existence. EPA turns out to actually have a lot of cases involving it that are being cited by courts in other EPA cases, but in many other decisions as well. And if anything, this is arguably an undercount. Why? Because we also look at about 12 different prominent administrative law decisions over the years, and maybe other administrative law scholars would have different cases in here as their top 12 administrative law cases, but we suspect that these cases would make, most of them would make anybody's list of important administrative law decisions over time. And again, looked at citation patterns throughout the federal courts, and the number one decision, and this is not new really, but it's worth noting, is an EPA rulemaking case, Chevron versus NRDC. Of course, by the way, I would just note that when we were looking at these patterns here, we were looking for the name of the agency, Environmental Protection Agency, which means we didn't even capture these that cited Chevron, because Chevron versus NRDC does not have the EPA in the case name, even though it was a case centrally about EPA rulemaking. But what's interesting about these 12 cases is how, 3 of them are decisions that did involve the EPA. So that's another way of saying that EPA's rulemaking litigation is important. It's cited a lot, and they've made important impact on administrative law more generally. And of course, I can't overlook the fact that EPA rules can get a lot of media coverage too. And the West Virginia case is certainly a case in point. I thought it was striking that yesterday morning, when my alert came from the New York Times, from David Leonhardt, giving a preview and commentary of current news that he issues every morning. Yesterday's newsletter was focusing on the 5 biggest rulings to be expected from the Supreme Court over the next several weeks. And abortion clearly was at the top of that list, but down not too far below that was the West Virginia versus EPA case. So we have this media attention to EPA rulemaking. We have the courts paying attention to EPA rulemaking litigation. I think we ought to try to figure out more about EPA rulemaking litigation. And we can start by asking how often are EPA rules challenged in court. I should say at the outset, for anybody who's not familiar with the legal rules about challenging environmental regulations in court, there are a couple of features that I think are important just to have in mind as I go forward here. First of all, the challenges occur in the Court of Appeals directly. The agency has established the record. You can think about, in some sense, the agency record-making process as akin to what a trial court does, is building the factual record in normal civil litigation that then can be appealed. Most of the major environmental statutes not only specify that the rule challenges would go to the Court of Appeals, but many of them also say that many EPA rules need to be, if they're going to be challenged at all, they need to be filed. Those rule challenges need to be filed in the DC Circuit Court of Appeals too. A second feature that I think is important, not only that this is going straight to the Court of Appeals, but that rule challenges have to be filed on a pre-enforcement basis by and large. In most of the major environmental statutes, there's actually a mandatory filing period following the issuance of the final regulation by the EPA. There's often a specified period of time, 60 days, often 90 days, in which if anybody is going to challenge that rule, that's the time period that one does it. So that's important, I think, when one is looking at data, because you get actually some degree of assurance that you're going to be able to capture all of the activity. It's not as if we have sort of the possibility today of somebody filing a lawsuit suddenly challenging a rule that EPA issued 10 years ago. No, if it's going to happen, it's going to happen right away. And so we're going to be able to really answer this question with our data. Now, I want to start off with, though, what our priors might be if we look at what's been said before about the answer to how often are EPA rules challenged in court. The typical answer that everybody, I think, would probably remember, at least, even if they might not know the full history behind it, is that about 80% of what EPA does is challenged in court. And this statistic of 80% has its origins with some speeches and publications that that Bill Ruckelshaus offered in the 1980s. As I indicated at the outset, Bill Ruckelshaus was the first EPA administrator, but then he came back in the Reagan administration after controversy over the EPA administrator, the first EPA administrator that Reagan had appointed, a woman who happened to be the mother of current Justice Neil Gorsuch. After she resigned, Reagan brought back into the EPA Bill Ruckelshaus, who had a stellar reputation and was there to kind of right the ship. Now, the interesting thing is Ruckelshaus said, when I came back to the agency, and he writes about this in an article actually in the I believe in the Houston Law Review. He says, I came back to the agency, and within 48 hours, a decision I had made had been challenged in court. And he says, I asked my general counsel, how many of our decisions, rules, policy, everything, how much of that is ending up in court? And he says his general counsel comes back to him a week later and says 80%. And so Ruckelshaus gives this statistic in some speeches. It gets picked up by the New York Times. And by the time I come around in the mid-90s and I'm starting some research in this area, I find that there's a whole lot of citations to this, so much so that the law review editors, when I wanted to cite all of these, said they're going to take up too many pages. So we had to put it in an appendix, and that appendix itself spanned quite a number of pages. And now, lest you might think, well, this is some ancient history here, you should know that this kind of thinking still prevails. Dan and I cite some more recent publications that indicate that people think that virtually everything EPA does ends up in court. In fact, I will say I was just involved in a panel discussion yesterday evening, and a very well regarded and properly well regarded scholar in the course of the conversation says, well, at EPA, everything they do gets challenged in court. So is this really the case? I came to actually looking into this statistic in part because I was doing a study at the time of negotiated rulemaking. And EPA had, at the time, been the agency that had done more negotiated rules than any other agency. And the question I was trying to answer was, does negotiated rulemaking actually reduce the amount of litigation over an agency rule? So rather than go through the normal process of putting out a notice of proposed rulemaking, taking comment, and issuing a final rule, the negotiated rulemaking process tries to involve affected interests early on to hammer out a consensus around a proposed rule. And then the idea being, if all the parties kind of had agreed on this, it should reduce the amount of litigation. Well, it turns out, if litigation is happening all the time, it's going to be hard to make that. If there's just a small sample of negotiated rules, how much confidence can we have that there's anything different? Well, it turns out that in the course of this work, I come to learn that the 80% statistic at the time I was looking, the data I was looking at was about the opposite. It was about 80% or so of EPA rules that don't get challenged in court. And in fact, in the latest work where Dan and I synthesize existing studies, we find that similarly that there's ranges of rates, but there's really differences in the samples. And when one looks at the biggest sample of all of the rules, In fact, one study by Chris Schrader and Bob Glicksman show only about 3%, 4% or so. There's much less litigation. It's not all the time. Now you can, as with any fraction, you can shrink the denominator down. And if you're looking at just, say, the most significant rules, if you say, well, let's just take the Clean Power Plan, for example, well, that's 100% litigation right there, right? But when you're looking across the sweep, the reality is that EPA is issuing hundreds of rules every year, and not 80% of them are getting challenged. What Dan and I did is take a look over time, and this at the figure at the top, actually, to my knowledge, has never been compiled before. This just shows you on an annual basis how many regulations EPA has issued in a given year. And you can see that certainly in the first year there wasn't that many in 1970, but EPA only started in its existence in December of that year. But actually, within a very short amount of time, it's up at 200 and 300. And on average, it's about 400 or so regulations over time. Some dips in the Reagan years, less, but still hundreds even at that time. And even during the Trump administration, still hundreds of EPA regulations. We also and show down below that the line with the triangles, what the court decisions look like involving EPA as a party now over that same period of time. Now, the court decisions doesn't mean the same as rule challenges, right? Because just like in the civil litigation context and just like with the criminal law, there's a lot of bargaining that goes on. And the work that I did, which focused primarily in the 1970s and 80s litigation, my earlier work showed that maybe up to 50% or so of the time these rules are challenged and then voluntarily dismissed before. Anytime they're about half the time they're challenged, they are voluntarily dismissed through a settlement process or some kind of agreement or understanding. In fact, it's not so surprising that there would be that settlement, because remember, in order to preserve your right to challenge a rule, you have these limited windows following the rule's finalization within which you have to file. So, sometimes groups will file just to get their, get in the court, make sure they preserve their right to litigate. But then they look at the rules some more. They may have some conversations with EPA, figure out maybe, well, what they thought was a problem isn't a problem, or maybe there was a technical error and EPA fixes the technical error. And then other times there is, more robust settlement discussions and the like as well that go on. So one shouldn't necessarily see these court decisions as the representing the total number of rule challenges per se. But what's interesting is how pretty much steady that is, and of course how much smaller that trend line is, or that line, how much lower it is than the number of regulations. If you look at now just the fraction of appellate decisions divided by number of EPA rules, this is basically what you get. There's some fluctuation going on here, but this is, with the exception of a few years, really, well below 15% in most cases. In fact, on average, it's about 10%. And if one compares the era that Judge Wald was writing about before or at the 25th year anniversary mark with afterwards, you actually see that the average before is about 10.8%. After is 9.8%. And you might say, oh, wow, the litigation's actually reduced. You shouldn't really read anything into the differences here. They're not statistically significant. And by the way, we also looked at these data with a lag. You might think that, because these are appellate decisions, there's going to be some time lag between when a rule challenge is filed and when there's a decision, and that doesn't make any difference either. So once these rules are challenged, and they're challenged a lot less than most people think they are, how does EPA actually do? Well, we again take a look across a range of studies, and there's actually in these studies 3 measures of EPA victories, and all of them suggest that EPA does pretty well in court. I mean, if you're looking at and counting by the number of cases in which the EPA wins everything, the petitioners lose all their arguments, EPA wins on almost about 50%. Now, in any case involving an EPA rulemaking, there's bound to be multiple objections that are being made. So other studies look at the number of issues that are raised and how often EPA wins on those, and they're winning most of the issues. And then another set of studies looks at, well, we'll just count the judicial votes for EPA, and judges are voting. It depends on part of the differences here are different time periods. Part of the differences are different sample strategies. Some are looking at all EPA rules. Some are looking at just rules under certain statutes. Some are looking at cases that raise any kind of objection to EPA rules. Others are looking just at statutory interpretation challenges and what might be called the Chevron type cases. But it is striking that EPA is not, and quite frankly, not much different than other government litigants in this score, winning. They win a fair amount. And by the way, I should refer to a study that was done some years ago looking at what happens after agencies lose. The remedy in these cases, when it loses, a remand back to the agency, which allows an agency to do it over. And the research indicated that when you look at what happens after a remand, agencies are able to come back and in about 80% of the time redo things and get exactly what they wanted. Now, this is not to suggest that EPA doesn't lose at all. I mean, the Clean Power Plan actually was stayed. The Waters of the U.S. rule under the Obama administration stayed by courts. We have the Mercury rule recently, in recent years, taking a loss. There can be important policies that do get struck down or remanded by the courts. It's not by any means to diminish it, but it is to say that we shouldn't be thinking about the agency, the EPA, as being beleaguered by litigation. It's going on and it's issuing hundreds of regulations every year, and it's not getting sued in most of those. And when it does get sued, it's winning a fair amount of the time. So what should we take as implications and conclusions? I want to come back in a way to the predictions and the observations made by Judge Bazelon and Judge Wald. And first say, I think that Judge Bazelon's prediction of a declining importance of judicial review doesn't seem to have held. If anything, it's been like Judge Wald had indicated, a degree of continuity over time, with a roughly constant rate of EPA rules being challenged and seemingly stable success rates. I think one looks across the studies on EPA win rates at different time periods and sees very much a similar sort of pattern. What might really be explaining what we find, this continuity, I think it is partly what Judge Wald observed, that the doctrine itself does allow judges still to scrutinize rules or defer to them. That's been built into the doctrine from really the earliest days. We have, for example, at the same time the court is deciding Chevron, it's deciding Motor Vehicle Manufacturers Association versus State Farm, which is the canonical hard look review case. And in that same year, it's also deciding Baltimore Gas and Electric, which is saying that when agencies are operating at the borders of scientific knowledge, courts should defer to them. So we have, in the doctrine itself, tensions, but we also have, and I do think to give Judge Bazelon some credit, I think his theory about emphasizing the importance of agencies doing their homework and having integrity in their internal administrative process probably also explains the observed equilibrium. As the doctrine may have shifted, or as it has these tensions, what the EPA has done, I think, well, has and well enough to maintain a rather kind of steady state, if you will, of not getting sued all the time and winning at least as often as not, has been the quality of the staff work, the lawyering that the agency has done. They've invested a lot in not only their legal counsel office, but in their policy analysis shop and in public engagement as well. And they've been able to manage at a time, quite frankly, when you might have expected over time for litigation to increase. Why? Because there haven't been any new major statutes really of note since the 1990 Clean Air Act amendments. So the latter part of the agency's history has been one of addressing newer problems or issuing newer rules under older statutes. You might have thought that the agency would have actually been faring worse over time and maybe would have even slowed down its rulemaking over time, given that. But it hasn't, and I think a good chunk of the answer is the staff work. So let me just conclude by saying now, the obvious lesson I think always here is that you should look for the data and don't trust sort of conventional wisdom or folklore about empirical claims. We should always look at that. But I also think there's a deeper point here about how there's a dynamism to law. I think there's a tendency, can be a tendency for lawyers to think about doctrinal changes as making sort of really pivotal and unchanging obstacles for agencies, for example. But agencies can adapt. And I think that's part of what we have seen here, that judicial review doctrine did give the courts an opportunity to restrain EPA, but the agencies also have lots of reasons to win, and the good staff work and the good lawyering when developing regulations is important. And one of the outliers, if you will, or one of the points of variation with respect to good staff work and good lawyering might be really what we saw during the Trump administration, when the political leadership at EPA, at least initially, really locked out, I think, a lot of good staff work and really worked very quickly. Jonathan Adler is called attention to the kind of the shoddy work, what he called quick and dirty deregulatory efforts that the EPA had undertaken, and it manifested in a loss rate that was quite significant if you compare it with the general trends. I mean, NYU kept a tracker of litigation, and about 31 of their court decisions in their tracker involved EPA actions, and the agency lost in 28 of those. So I think maybe the lesson from all of that is that the good staff work. And what might the future hold? Well, I don't have a crystal ball, but I do think that there may be some blockages depending on what happens in the West Virginia case. If they overturn Massachusetts versus EPA, for example. The EPA will be really hampered in addressing climate change under the Clean Air Act. But on many, many other issues, I would suspect that the agency can continue to regulate for environmental protection, and if it does its homework well, fare well in court. So open to your questions, and looking forward to any discussion you may have.
Thank you so much, Cary. I'm going to take the prerogative of the host to ask the first question or get your opinion on something as we put up the CLE course information. I thought that Case Western program, by the way, the 50-year program was really interesting and well done, and I really appreciate your contribution to that. And while it's interesting to me because you clearly prove your point, and yet when I look at all the data, I think, well, but the story that EPA is the most beleaguered, it's the agency most challenged on most of its major rules. It's the punching bag for the political, AGs in all of these states and both sides, et cetera. It still seems to come through. But I want to just pull back for a moment and take advantage of your amazing expertise in administrative law and policy. And so if you were at the 60,000 foot level, let's go to satellite orbit. When you look at what Judge Bazelon said, and then what Judge Wald said, and particularly the reactions, with the introduction of Chevron, how much of what we see in this 50-year history is really part of the story of the tension between sort of judicial control, the judicial branch and the executive branch, right? Because you do see more search and review in the early 70s, right? That's a real thing, or at least the judges say they're doing that. And then you see what apparently is a pullback with Chevron, and yet is it really a pullback? And then when the judiciary or the big powers that be the judiciary are particularly unhappy with the executive branch, now you're seeing the push, of course, on the major questions doctrine, and even a possible revitalization of the non-delegation doctrine. So is all of this simply vibrations in the tension between courts and the executive branch? What are your thoughts on that?
Well, I think, the empirical research, Emerson Tiller has done a very, very good study looking at what the levels of deference were on statutory interpretation questions before Chevron and after Chevron, and they don't change. There are lots of reasons for courts to defer to government, and government does have authority. First of all, there is, and I don't think even under any of the most conservative justices they would deny that Congress can empower agencies to act. In fact, if anything, their concerns are that Congress isn't speaking clearly enough. But if Congress does, so there is a role for the administrative state now. So, and I think with Chevron, there will continue to be lots of reasons for courts to effectively defer to agencies, or have the agencies continue to win in statutory cases, even if they don't have the Chevron doctrine to cite anymore. Why? These are complex matters. Agencies do their homework generally. They can put forward a convincing case to a generalist judge that what they've done is responsible and sound. And this doesn't mean, again, there won't be individual decisions here or there, but I don't think we're going to find, if Chevron is repudiated, and it might be, by the way, in some decisions that the court may hand down in non-EPA cases in the next couple of weeks. It could be repudiated. I don't know that it will eliminate the ability for agencies to win in court. I think those dynamics will often still be there.
Well, and I do think
yeah.
your conclusion bolsters that idea, kind of going back to what Judge Bazelon said, that whatever legal or litigation environment the agency finds themselves in, they're of course going to try to make make their regulatory things as bulletproof as possible. I mean, I'm sure you have too. I know people who write the rules, right, for for the Clean Air Act, and that they spend years and months and thinking about this. And again, a great example of how that didn't work, I think, in the Trump administration, because there was just no sort of attention to that expertise or no deference to it. So that, I think, is always true, and that will bear out in the win-loss rate, right? But then how much does it actually affect what the agency can do? Well,
that is the, I think you put your finger on really the important question, right? So one of if you're looking at this from the general counsel's office and you're trying to manage litigation risk, I think these data show that they're pretty good litigation risk managers. Okay, but in managing litigation risk, do they advise the EPA to scale back, not be as protective on some issues than they might have been? And it varies, I think, from statute to statute, issue to issue. I mean, clearly, if West Virginia comes down, and again, Massachusetts versus EPA is overturned, and the court says, well, climate change is a major question, and it's really not clear, and that EPA has this authority, Congress has to give it. I mean, if it goes the way of the OSHA vaccine case and the CDC eviction moratorium cases, then it's going to have to be up to Congress to authorize it, and that will be, there's no way of sugarcoating that, right? That will be an area of regulation that will be off limits to the EPA. And you might say, well, yeah, and going forward, there's going to be no losses in court over climate change rules because there won't be any climate change rules, right? So I do think that's fair, and I think climate is the area where this is of greatest concern. It's not clear that there will be a lot of other areas.
Right, and what's interesting is, of course, before the early 2000s or mid 2000s, they didn't think about the Clean Air Act and climate, right? We need to do climate as its own thing, and it's separate, and it does show how those things change. There was one question in the chat, a technical one, about your cases and about whether the denominator for rulemaking included the state implementation plan rules. Because those are, I think, technically rules where EPA approves or disapproves a state implementation plan. That's probably in the article, but I just thought I'd bring it up since someone asked.
Yeah, it really is a function of how it's listed in the Federal Register. And, I think that I've seen some entries where it's not indicated as a final rule, others where it is. Of course, those are potentially challengeable as well, and so I wouldn't exclude them just for that reason. In fact, some of them can be quite consequential for major states and the like. So
exactly. Well, thank you so much for your wonderful presentation and sharing it with us in terms of this program. And I will leave the last word to you first, and then to Aubin to help our CLE friends. So any parting words?
Well, let me just again, Victor, thank you very much for having me here. And I've enjoyed the opportunity and really, really do appreciate the honor to be with you.
Thank you. All right, that will be the end of our program. Thank you all very much. We'll see you in end of June with our next program with Professor Elliott from Yale. Thank you. Bye-bye.